Get started. Call the Judiciary A to order. A little housekeeping matters. We will meet on Tuesday with our regularly scheduled, our standing meeting. We may meet before that. As many of y'all know, we have a number of bills. The Women, Children, Family Committee from this fall, those bills came through our through Judiciary A. So there's a higher number this year. So to get them all in, we're trying to do that. But right now we're meeting on Tuesday at our regularly scheduled time. And then today we're gonna have a number of double referred bills. So forgive me for skipping around, but that's what we're gonna tackle first. And so I'm first on that, I'm gonna call up Senate Bill 2088, and this is double referred to appropriations. And I will call on the subcommittee chairman at times. Some of these I think I can hit real fast. So this is 2088 is increasing the operating allowance for our district attorneys. And the bill is increasing it from 35,000 to 70,000. It's passed out of subcommittee. And there will, a fiscal note was required, so we'll go to appropriations and to discuss that. So any questions on 2088? Senator Turner Ford.
This problem. Thank you, Mr. Chairman. I'm trying to turn to the bill, but my question is, there's an increase that's being allowed for the DAs. Who will be responsible for covering that cost, or how will that be determined?
The state already covers the cost that's in there.
So will there be an increase in what the counties are required to pay to the AOC?
Not
Oh,
in this
you
bill.
said this is the DAs.
Yeah, this is the DAs.
So there's no additional money that will be required by the counties?
Not that I know, not written into this that I know of.
Thank you.
And the fiscal note has been prepared, and I know that can be taken up in appropriations. Sorry, my recollection is it runs in the hundreds of thousands statewide. All right, do I have a motion? Motion's title sufficient, do pass. All in favor, say aye.
Aye.
All opposed? Okay, thank you. That one passes. Call up 2645. This is also double referred to appropriations. This is in a little bit of background. Speaking of our district attorneys, this is providing and reassessing the district attorney positions in the state. And this bill is an agreement of all the district attorneys in the state. And so, to be quite honest, they got together at our request because we are going to have to do this either probably next year or the year after. And so they said, these are the DAs that we think the areas that need DAs, the ones we've agreed to it. And so a fiscal note also has been requested on this, go to appropriation. And so it's increasing in these specific areas, the number of district attorneys. And that's the bottom line of it. Senator Hobson.
Thank you, Mr. Chairman. Have you received the data from the DAs as to caseload for each of the district attorneys?
No. Oh, okay. Thank you. The subcommittee did, and they talked about that. Senator England wants to discuss that.
Well, if I may finish, make it a two-part question then, if he's going to discuss it. What did the data reveal on caseloads, or can we get a copy of that? And secondly is, what's the fiscal note? You said it was being requested, but I would like to know, I will need to know, have to know what the fiscal note is on this.
The fiscal note is in round figures around 6.5 million.
Yes, thank you, Mr. Chairman, and thank you, Chairman Hobson, for your question. I think I was paying enough attention to answer it for you. What I've given you there is a graph form that shows the number of counties in each of these districts, number of cases they're currently looking at. Yes. That from 2017 to 2021, and then you'll see in those last two columns, that's the number requested for each district, and then the number of investigators that have been requested. So there's a total of 43 new ADAs in the state and 8 new investigators. Does that answer your question? Oh, in a fiscal note, I believe Chairman Wiggins did address that.
In terms of the caseload, and I think Senator Hobson's question is caseload like cases. So that when that chart was put out and all the requests was made to look at those things. And so this was from the MPA, and this is how they assess the caseload and base that on there. So if you're asking if I sat down and looked at the caseload, I have not. But this is the agreement based on, and I think they worked really hard on it to present to us a fair plan.
Well, I think that's my question, Mr. Chairman, is who's looked at it besides the DAs? Of course, we're all friends with the DAs and they do a great job. But I mean, I look at this, and by way of example, I'm looking at the 17th. I'm just going to pick 17th Judicial District, and you've got 3 DAs asking for 1 more, and you got 17,000 cases. And then you look at the 16th, you got 7,600 cases, already 5 DAs, and they're asking for 2 more. And their violent crimes are higher in this first one that I mentioned. I just can't make sense of how this is even remotely fair. And I know they've given you information. Each of them has wants and needs for their office, but statistically, it's hard for me to be able to support these. It just seems very inequitable.
Well,
based on this chart.
That's why I think it's been double referred to appropriations, and I think what
Thank you.
So that's why it's been double referred in the fiscal note 6.5 million. And what you're highlighting, Senator or Chairman Hobson, is some of the discussions that I've had with them. Senator Parker.
Thank you, Mr. Chairman. I may be able to shed a little bit of light on that from the subcommittee hearing that we had before this that led into this. If you look to the 23rd Circuit with Bob Morris there, it says C-17th. And so the 23rd is my district. So I was wondering, okay, what does C-17th mean? And so I did a little more research into the chairman's point. We have a unique situation in our area where our DA, John Champion, had been battling a brain tumor for quite a long time. We've just had a recent new appointment of Bob Morris to fill that position this past year. And so I had detailed conversations with Bob, and I got our numbers, and our numbers are extensive. Just by comparison here, DeSoto County, which is the 23rd, we have about 190,000 people in our population in DeSoto County. And in this situation here, the number that's been requested, the 3 that you see on the 23rd, is 1 short of what they asked for. And so according to my district attorney, there was some trouble in the clarification between the 17th and the 23rd from some of the reorganization that I think you did that has led to those numbers being a little off. Our numbers represent that, for example, Hines, which has the highest population, has 11 ADAs. Harrison County has a population of 209,000, has 10 ADAs. And, DeSoto County, which is the 3rd most populous county. And we have Shelby County right next to us. Shelby County has a population of 924,453. And as many people know, and as you will see in your news today, some of the crime problems in Shelby County do spill down into DeSoto County, which leads to, more of a load on us. So to clarify that, in my consultation, I believe that this was somewhat of a clerical error here. So this is not my pitch to say we've got to have more, but according to my district attorney, I would like to make an amendment at the proper time. And that amendment would be that on line 58 of the bill for the 23rd Circuit Court District, we would change 7 legal assistants to 8.
Well, let me say this, and this goes to both Senator Hobson and Senator Parker. As I said, this is an agreement. I think Senator Hobson knows that if we get into this is partly to avoid a Christmas tree, because we all know that a Christmas tree is going to happen because it's happened in the past. And this is an attempt to avoid the Christmas tree. And that was it. And so Senator Parker, if you do that, then every other person whose district is there, they're going to want their ADAs. And then we're going to get to where it's $10 million and nobody's going to get an ADA. So this was an agreement that was done with the Mississippi Prosecutors Association by all the district attorneys.
Well,
And I will say to that it's not really fair if that district gets one and then somebody else doesn't get it, because then that's violating the agreement that's been brought to us at the request of both them and to try to get somewhere on this.
well, with all due respect, yeah, I laid out the circumstance of our district. Our district attorney at the time was unable to be at the seat, unable to be as the lead of our county, as the 3rd most populous county in the state, to be able to share the true data. And the person in the lead is the one who champions the cause. And on the list that I have in front of me, I don't see any other district that says see another district for information. Ours is just sitting there. It's almost like our numbers don't really show up in this graphic here. And that's why I went to our district attorney and I asked him, and he said, absolutely, that was not what they asked. That was not what he asked. And that is not what they need, so I would be very glad to share.
Well, yeah, if
caseload.
you're willing to, now's the time to make your amendment if you want to make your.
Right. So my amendment would be respectfully to make that change. And my intent in the amendment is not to create a Christmas tree where we're adding things where there's not a need. But I will say that in my research on this since the subcommittee yesterday, and my research has been pretty exhaustive, I do believe that we have at least that need, perhaps more, but that would be a great help to us. So that would be my amendment.
Senator Hobson, are we
This
on the amendment?
On the amendment,
Okay.
because I think it's pertinent to not just the amendment, to the entire discussion about the DAs and the needs. I don't deny that there are some districts that need additional DAs. What I had hoped, and I don't know if this is the will of the committee or the will of the legislature, is that we're right on the cusp of doing judicial redistricting. And there is the possibility that if that is done this year or next year, looks like it's going to be next year. If that's done, their districts may be realigned, and you may not have a need for DA if you move some counties around. And I think that would probably come through this committee. But what happened when we did it previously is there was an attempt to realign the districts so we could balance caseloads a little bit better. There might be a county next to one that's got a low caseload, you could pull into that district. And there might be another county that's low, like DeSoto County. You may have to break them up a little bit in that area because they have too many counties. And you could shift and work the caseload of DAs and judges at the same time, so you have a balanced caseload. I feel like, even though I don't deny that there are some people that might have needs, that we're going to be a little bit scattershot on this by just saying, this is what they all say they want, need. Nobody's going to care. If I'm in the 9th judicial district, I really don't care if Senator Parker's the DA in the 17th. If he needs 2 or 3, that's fine. I take his word on it. He's going to take my word on it. I don't know that that's the best approach to go about the process of realigning the need for ADAs. I think it needs to be more statistical based on the information and some good parameters. That's just my comment, and I'm concerned about proceeding with the information we have, because this is not, look, it's very clear. You can look at this. I mean, I've gone through and picked several others. I just picked that one. This is not really equitable based on the caseloads as presented here. Mr. Chairman, thank you.
May I ask the Appropriations Chairman? So if part of this was to avoid an inordinate amount of costs to the state and provide the resources, if this doesn't proceed forward either in this committee or in appropriations, then what we're looking at, you're right about judicial redistricting, that we're looking at, rather than a $6 million going forward, we could be looking at, 10 million or 15 million. Because I think that's what's going to happen when we get to that stage next year. Because unless we choose it ourselves, and we're going to say, and then we're doing it over the objections of the district attorneys. So, right now, based on the fiscal note that's been provided, the budget process is looking at $6 million allocated, and basically $6 million for the next however many years. Now, I guess we're having the appropriations. So that's what I think has been tried to be addressed with this agreement. And are we willing to say, to take that risk, for lack of a better term, going forward?
Well, I feel like it's kind of a rhetorical question. I don't know that I could really answer that.
We could
because
pass it out
You don't know
here
what
and
they
see.
are, but at the very least, I just think this has got a lot of work to do. And I don't know if that means put a reverse repealer in it. I don't know if it means we just, there may be some districts that are absolutely just desperate for a year to have somebody. But I would hope that if we were in next year and you were the chair of this committee, you're going to take care of the exhaustive work that I think that we all deserve, and the whole committee, to look at the caseload numbers for the judges and the DAs at the same time. And it's a lot of work, I know, but I think that's what's the best thing to do, rather than scattershot, kind of like we're doing, I feel like, right here, Mr. Chair. And no disrespect, I know I don't disrespect that. I just think it's what I said earlier.
None taken. But I will say, I think the request was made, and they, to a degree, we are taking through this bill, taking their word at it, because they did go in and they did say if you look at, there's some of them that, they maybe wanted 3, but they all agreed through the MPA to we'll take 2 instead of the 3 that we actually need, because they were putting the group of DAs ahead of one individual need. So we recognize that, but I think the will of the committee, I think the committee's heard this, so, we can go forward. So right now we're on the amendment to Senator Parker. So
Can I briefly close then again?
yes,
For comment? So just in closing, I understand your point, Senator Hobson,
on the amendment.
and I also understand your point. I think,
Well,
that-
Senator Parker, I'm going to give you, apparently we have some questions. Before you close, I'm going to
For
give you the
Senator
right
Hobson.
to close. So
Senator Parker, the sheet that we have in front of us has the number of cases per DA. And I'm not going to disagree with you that DeSoto County is really fighting crime hard up there. Do you have the numbers that we could fill in just by comparison? On the sheet we have in front of us that has the number of cases, the number of violent crimes, and then the number of cases per ADA. Do you have that information?
so from 2017 to 2021, the 17th district already carried the highest average number of cases at 495 per ADA. The third highest number of cases was 17,325, and the third highest number of violent crimes, 2,872. And to Senator Hobson's point, there has been, there needs to be some alignment and changes like that. But from our county standpoint, and I've said this before, from 1990 to 2010, Olive Branch was the fastest growing city in the United States of America by population growth percentages. And we, in this last redistricting that we went through, pulled a entire senator. We now have 3 complete senators and 1 half senator within DeSoto County. So we have 3.5 senators in DeSoto County and maybe too many representatives. But and in jest. Yeah, but I just say that because I understand your point, Senator Hobson, but I also know that we have a desperate need because we have investigators who are just serving, they're prosecutors, but they're just, they can't do what they should be, and it's a need where I think we need to do something. And I don't, to your point, I don't know exactly what that is, but if this gets us there, and the numbers are wrong and we need to realign them, I would prefer that approach, to delaying it, because if I recall, I think we've been through this, maybe a couple of other times, and I think the need is great enough that I would prefer to act on it. And, if that meant me only getting 3, that's the will of this committee, but I just will share that, our need is greater than that. So with that, I'll stop talking and closing on my amendment.
Question,
Well, but before,
Senator Barrett.
yes, sir. Thank you, Mr. Chairman. And if I'm out of line, please stop me. But before a vote is taken on the amendment, for 3 years, I've filed a bill with statistics showing the need for more judicial officers in my area. And it was referred to this committee. And I guess I can summarize, or maybe hopefully somebody can. I get I'm the new guy here, but I keep hearing judicial redistricting, judicial redistricting, judicial redistricting. So I guess it would help me with my constituents if I knew, is there, and this is a sincere question, is there a fast and hard date for judicial redistricting, or is it just something that we as a body decide to do when we decide to do it?
Yeah, so I'm going to rely the Lieutenant Governor's office, and we researched that before this session. And the hard and fast date is we have to do it before 2025. The law it says within 5 years of the census. So we just did the census. We have to do it within 5 years, which means next year.
Okay.
So generally it was every 10 years, or I'm sorry, every few years, depending on that. So according to research from the Lieutenant Governor's office, we have to do it within 5 years of the census.
Okay.
To review that, because the population has come out and all that.
Well, thank you. That helps me understand Chairman Hobson's concerns and Chairman Parker's. Thank you.
I think Senator Branning.
I've got a motion at the appropriate time.
Okay, go ahead.
Just based on the way the conversation is going and the concerns raised, I think it's appropriate to add a reverse repealer so we can keep working on this, but keep it moving at the same time. So that's my motion.
Okay,
I would consider that a friendly amendment to my amendment.
okay. So we have an amendment to the amendment. So, yes. Yes, that's right. Senator Hobson, we're on the amendment.
Just for clarification, we are, the amendment now would be that it's to add a DA in Senator Parker's district, the 23rd or 17th, and to put a reverse repealer.
Correct.
Thank you.
That's right. Everybody understand the amendment? All in favor, say aye.
Aye.
All opposed? Amendment carries. All right, we're on the bill itself. Do I have any other questions? Okay, Senator DeBar.
Thank you, Mr. Chairman. I'm looking at line 121, and it directs that the Board of Supervisors that have a population of 24,350 have to pay for a legal assistant.
Yes.
Why that number, and what's the rationale behind that language?
Because the Board of Supervisors in that district, which is the circuit court, have chosen by their own accord to withdraw funding from the district attorney in that area, even though the district attorney and the law requires or has requested that, that the counties pay for it. So that language is in there to address that one particular area.
And so this specifically addresses George County.
Yes.
Is that correct? And so the George County Board of Supervisors, in their discretion, have withheld the funding because they felt it appropriate. And now this is directing them to pay for it.
Well, for probably a decade, the George County Board of Supervisors, along with Greene County Board of Supervisors, have funded a DA in that area. Because the George County Board of Supervisors, even though they want representation as they should have it, they chose to withdraw their funding of that. Greene County has not chosen to do that. They like it. So that's what that language is trying to address, is that they honor the agreement that they made before.
And the rationale behind the Board of Supervisors decision was that they would like a DA assistant in their office, and that the DA actually sits in Jackson County, and the DA's office refuses to put anybody in George County or Greene County. Greene County may withdraw here shortly. That's what I understand as well. So the fact that they don't have a DA that in their office, that the grand jury hearings are not as often as they need to be in Greene and George County, that as a last resort, the Board of Supervisors decided to withdraw funding to try to get the attention of the DA, and who is still not willing to put a DA in George County as per the agreement that was made 10 years ago.
This may be why Senator Hobson brought up redistricting and
That's
the
correct.
population and what goes on with that. But we do have an adverse repealer in the bill right now, which we all know what that does.
I
And
understand.
my guess, listen to Senator Hobson, I'm not a betting man that it'll come out of appropriations at this point.
Well, I just wanted to make sure that's what we were talking about.
That's what we're talking
And
about. And you're very
hopefully-
astute.
We can address this hopefully next year, I hope.
Well, yes, and let me say that, Senator Barr, you and I have been put in that situation. We didn't ask for that situation, but sadly, our counties have been put us in that situation. And, you know, I'm sure this kind of stuff goes on in other counties too. But that's where we are. And I would say that's why in the law currently, it says counties can choose to decide that. But hopefully we can address that. And maybe it needs to be addressed through redistricting like we've talked about. But I will say this, back to my original statement, this is why this agreement came forward from MPA, because I think these discussions are going to happen should we go through judicial redistricting and DA. All right, so we have, before anybody else question, Senator Boyd?
No questions. Speak on the bill at the appropriate time.
Well, now's the appropriate time because we're on the vote.
Okay, thank you. I understand, and I completely agree with what you're saying, Senator Hobson, that we need to figure out a way to do this equitable. I will say this, though, back to one thing that you said, are there some immediate needs that need to happen before a year? I would request that as we're looking through this and as you're looking at appropriations, there are 4 districts on here who the caseload is over 400 per ADA. And if you also look at those violent crimes per ADA, the number of violent crimes in some of those districts, there are some significant needs here. And I would ask that we take a special look at some of those districts that seem to have a very high case volume of those ADAs to see that if we can give some immediate release. This is something that in my area, they have very much reached out to me on, and I started this process talking about this back this summer early on with a lot of good documentation and facts from my district attorney that I'm happy to share with you on that. So I agree, we need to look at a comprehensive system, but I do think there are some immediate needs that we might need to look at and take care of. And that would be my request. Thank you.
Okay, so we're on passage of the bill as amended. All in favor, say aye. All opposed? Bill passes, goes to appropriation. Thank you for the good discussion. Okay, I'm gonna call, if you have, for the committee, you have an addendum, which is double refer bills. So I'm gonna call up Senate Bill number 2392, which came to us from County Affairs, and allow Senator McCon good luck.
Thank you, Chairman. This bill is the culmination of some 6 months of meetings, hearings, discussions on garbage liens across this state. I was not prepared to bring my data in here with me, but the last data that I have shows that we have right at $28 million across our state in unpaid garbage fees, and we continue to have a problem with that. As you know, we've worked on this over the last 6 months to get this wording. We've brought in all associations, circuit, chancery, tax, board of supervisors, land and title, and we brought some of the House members that came into our committee meetings whenever we had the hearings on it. So this bill sets up a few things, and one of those things is that it sets up the requirement for there to be a registry in the Chancery Clerk's office that says these fees are due and owed. And that was one of the biggest things that we've heard across the year, is that title attorneys have had a hard time determining whether there's a fee out there due and owing in that area. So the first thing is, it's got a listing of that you've got to have some kind of registry in place for the filing of those who are delinquent on their garbage fees. The second thing says that the Board of Supervisors shall annually update the delinquency notice to the tax collector, at least, well, not annually, quarterly. The discussion was whether to do it quarterly or annually, and the Board of Supervisors agreed that they were going to be able to do it quarterly, so that you know the amount of outstanding garbage fees. Next, this bill sets up the ability for a tax assessor's office, once there's been a delinquency notice issued, it'll go on record. And then the tax assessor's office, once that delinquency hits $500, to actually place it as a special assessment on the taxes to then be sold. So if they're going to sell the taxes that year, they could put that $500 or whatever it is above that as a special assessment on there. Now, that's going to take about 3 years for a generator to generally make it to $500. So we're trying our best to give plenty of time for people to go and pay their bills, come back in within that year, or whatever it may be. So 500 was the number they kind of got to among the associations. It does not take away the ability to hold their tag. It does not take away the ability for you to, pursue them under a civil remedy, a judgment. It does have, if you keep on moving over to 115, you'll see that there is a requirement for this filing to actually be done before September 1st, 2024, in order for it to attach to that real property. So what's going to happen is the liens attached to real property, they chose the January 1st, 2018 and after, and it's got to be filed by September 1st, 2024 for it to be considered a lien on real property. This does not take away, does not forgive any debt. This just says that if you're going to attach it to that property, then you've got to get it filed so it becomes notice. So there's notice out there for anybody that's running the title work on that. If you don't, it continues to be a personal lien against that person. They can still hold the tag. They can still do anything of that nature. But the deal is that if it's not filed on or about that date, then it is not going to attach to that property. And that was just trying to get that registry in place so they could do that. Lastly, it just says the Chancery Clerk's office will work with tax assessor, of course, to perform those sales. Now, I would open that up for any questions. I know we've had a lot over the years, and I believe we have representatives from those associations around. If you have some harder questions than I've got. So are there any questions on that one?
Senator Barnett.
Thank you, Mr. Chairman. What do you do in the event of rental properties?
Well, unfortunately, the statute continues to say that as you, the owner and the generator are jointly and severally liable for that.
So if I own a rental property but for someone to be able to have the water turn on, it's turned on in their name. Therefore, the garbage should be part of theirs too and not part of mine as the renter. So why, so it's like if they don't pay the water bill, it's not in my name. So why should I be, as a renter, should be held responsible for what that person didn't do as renting my property?
Well, the easy answer to that one is place it on the rent. I've got rental property as well, and that's what I do to keep from that happening, because the statute, the code currently says is jointly and severally liable on that as far as generator and the owner of the property. That's the easiest way to keep it paid. If they don't pay your rent, you're not gonna let them stay there. Unfortunately, as our state, we can't stop collecting rubbish because it's just what it says. It says we can't do that for health and safety purposes.
Any other questions? Senator Turner Ford.
Thank you, Mr. Chairman. What's this provision regarding the September 1, 2024, what is the effect of that? If something is not, if the lien is not recorded?
If it's not recorded on or about that date, then it would not be considered a lien on the real property. What that is there was some question as to whether we can get a registry set up in some counties within this year, and we said we couldn't do that. I didn't expect that to happen, so we chose an additional year out for counties to get their computer software, or if they want to do a written book there in their office, to get that in place and get it within that Chancery Clerk's office. If there is not a lien recorded in there, then any attorney that would go in there to run the title could rely on the fact that it is not in that book, and thereby would not be considered a real property lien on that parcel.
So that would prohibit wherever this occurred with these outstanding liens over, garbage collection fees that incurred over a number of years. If they are not recorded in this registry by September 1, 2024, they will not be a lien or attach as a lien to the property.
They wouldn't attach to the property. That's correct. It would continue to be a personal debt out there against those individuals.
And you mentioned quarterly, but as I see it on line 72, it says at least annually. Did I misunderstand your explanation
So,
about updating the notice?
Senator McCon, can I speak to that?
yes, please.
There was a committee sub in county affairs, and it's the last, I think it's one of the last bills in your packet, and the only change was quarterly from annually. Every other bit of language and deleted text is the same.
I see it now. Thank you. That's my last question. Thank you.
Thank you, Senator.
All right, any other questions? Do I have a motion?
Title sufficient, do pass committee sub.
Motion is title sufficient, do pass committee sub. All in favor, say aye.
Aye.
All opposed? All right, that carries. Thank you. And I know Senator McCon worked really hard on that, so appreciate your work. Going to call up on your addendum, Senate Bill 2729. That's coming to us from technology. Real short, and Senator or Chairman Delano authored the bill. Everything is new law. If you look at starting at line 59, sorry, said the wrong one. Yeah, if you look at line 59 of the proposed committee sub that came to us from technology, apparently, and I'm not on that committee, the ITS officer is able to negotiate contracts. And the only change to current law is that on line 60 and that on line 69, and allows them to address the liability and allows the officer to, I guess, designate or have a designee to look at those contracts. Senator Hobson.
Thank you, Mr. Chairman. As our council knows, I've had real consternation about this limitation of liability issue for state contracts. And I've been meeting as recently as yesterday or day before with ITS, and I've asked them to get with the AG's office. I do think something's got to be done on this particular issue. I don't know if this is the vehicle. I've looked at it. I don't think it gives me the assurances. I'm fine moving this forward, but I think it's got a ways to go before we get something a little bit stronger in place. So I'll let you, I would say proceed, but I don't think this is our best vehicle to take care of the problems.
Do you mind talking to Chairman Delano?
I'm happy, he knows about it too. Chairman Delano's aware, and I think this is something that he probably filed in anticipation of getting something out, and maybe we just haven't had a chance to circle back on what needs to be done.
Okay.
But I'm happy to get with him, and I'm happy to take it as a floor amendment. Since this is already past technology, I suppose, I'm happy to continue the discussion. But if we pass it here, I would ask it be held off as long as possible till we can try to come up with some good language to take care of what is becoming it seems like an increasing problem on state contracts. Thank you.
Any other questions? Do I have a motion? Motion is title sufficient, do pass. All in favor, say aye. All opposed? That carries. All right, I'm going to call up Senate Bill 2381. That has come to us from Medicaid. In short, and this bill's coming out of the hearings that have been had by Medicaid and actually the Women and Children's Committee. In short, when the contracts are let or the RFPs, particularly in the Medicaid space for our MCOs, what happens is they, and I'm understating it, get tied up in litigation for years. And Commissioner Snyder of Medicaid, when he testified, said it's become the norm that when these contracts are let, that it becomes litigation, and they actually have to budget for that and anticipate that. And then they get tied up in litigation, and then it comes around for the next RFP that hasn't been decided, and they're spending all the time. So what this bill is doing is placing liquidated damages on the losing parties who decide to challenge in court, and also provides for a bond. So if they are going to go into the RFP process and then they so choose to tie it up in court and do that, then they're facing liquidated damages and a bond as well. So Medicaid passed this out and sent it to us. So that's what the bill does. Do I have any questions? Do I have a motion? Motion is title sufficient, do pass. All in favor, say aye. All opposed? And that'll carry. Thank you very much. All right, moving back to that takes care of our addendum. I want to go to call up Senate Bill 2075, Senator McCon.
This bill is brought to us from Senator Hill, and there's a complementary bill from Senator Younger. This allows for an individual who has been adopted to, at age 21, request a certified copy of the person's original birth certificate, and it shall be clearly marked, canceled, and revised. That is the entire effect of the bill, and the language is there on the back. Entertain any questions on that.
Senator Hobson.
Thank you, Mr. Chairman. My apologies. Does this allow for a court order to be put in place if there's some reason for the child not to be able to obtain the birth certificate?
I don't see where it would prohibit that. If they were to go and get a court order, then it would bar them from doing that. And I see no other recourse for that from Senator Hill's language.
Yeah, I'm afraid if it's not included, the court would feel like they couldn't do anything about it because it's state law.
Yes.
And it just seems to me there may be certain circumstances because of something that happened in the background or something that was so horrendous or scandalous or abusive or whatever, that there may be an opportunity for at least someone to seek a court order not to release it for some reason. I don't know what it would be because I don't work in that field, but
I believe that would be a very fair and favorable amendment,
would,
as far as putting that in there. You know, unless, maybe just put in the language,
unless otherwise ordered by the court.
unless prohibited there,
Yeah.
or unless prohibited by the court, or unless otherwise ordered.
If that's okay, Mr. Chairman. Again, I haven't had time to read the bill. My apologies, but
That'd be the
if
motion to amend.
that's the motion. Thank you.
Can you restate the amendment, please?
Thank you, Mr. Chairman. I'm not sure where it would go, but I would just, the language would be that they're entitled to the birth certificate unless otherwise ordered by the court. So they would have to take, if somebody went in that wanted to stop it, they would have to ask the court to issue an order.
So basically, we would come in, a person who's been adopted is entitled to a certified copy of the person's original birth certificate if the person is at least 21 years old, unless, and put it in there. Would that satisfy the language? I believe it would there. So that's on line 73 at the end of that sentence.
I would defer to you and counsel on that.
Okay. So everybody understand the amendment? So we're on the amendment. All in favor, say aye.
Aye.
All opposed? Okay, the amendment carries.
Title sufficient do pass committee sub, unless you've got other questions. Sorry, just saw a light.
Motion is title sufficient, do pass, committee sub. All in favor, say aye.
Aye.
All opposed? Ayes have it. Thank you. While you have the floor, Senator McCon, call up Senate Bill 2653. I believe that's your bill.
Yes, thank you, Mr. Chairman. And this bill is just a one pager, and it's in light of everything that we've done over the last few years and everything that's going on around us. And as soon as I can find the bill in my packet here. The bill itself is set up to require that if you are a nonprofit that has received more than $200,000 from the state of Mississippi, you are required annually to submit a report of what you did with that money. Not a detailed report, just a report that we created. That really is that that we created a, that they created whatever they did, low-cost healthcare in the Delta or in Newton County or wherever it may be. Submit it to it. The concern is that right now there's no reporting mechanism to say what people are doing with the funds once we give it to them. And we're just asking for a simple report. From that report, then the auditor would have the ability then to question if it did not comply with what we did as far as our appropriations. So I would entertain questions on that.
Senator Parker.
So there's a similar bill that was reported out of Economic and Workforce Development with very similar provisions. The provisions were to, just as you've stated, didn't have a dollar amount on it, but it required the state agencies to do such. And also I went to Secretary of State. The difference is that the Secretary of State then would share the information with the Office of Workforce Development, because that is information they are looking to have too in some of the things that they're trying to do, because they are looking to create public-private kind of partnerships between business and industry. So I would suggest we go forward with your bill. My bill's already out of committee on the Senate calendar. If we could, Mr. Chairman, I'll get together with Senator McCon, figure out which of those is the best one, and maybe offer a floor amendment to get them to get the best answer on that.
I look forward to working with you on that, Chairman.
Any other questions? Senator Barrett.
Just a clarification, the only funds that will need to be reported are the public funds? Is
So
that correct?
as we would appropriate or we would send out any public funds, that's where it would come from.
Any other questions? Do I have a motion?
Title sufficient do pass.
Title sufficient, do pass. All in favor, say aye.
Aye.
All opposed? That carries. Thank you, Senator McCon. I'll call up Senate Bill 2153. This came to us out of Senator McConn's subcommittee. In short, what it's doing is it's coming for rental car agencies, and there are charges that get placed on rental car agencies by outside entities. And what this is allowing or requiring is those charges to be made transparent. And actually, it's kind of a little bit backwards. The rental car company is asking us to require it. And this has been done in 40 different states. And it's a consumer, I guess, a good consumer bill, because then they'll be able to see all the charges that they're being charged rather than it being hidden. Oh, and council's telling me that the committee substitute conforms it to current law. Is that right? Okay. Consumer finance. Okay. Do I have any questions? All right. Do I have a motion? Motion, title sufficient, do pass. All in favor, say aye. All opposed? Okay. Senate Bill 2082, the governor's office has reached out to me with some questions on that, and I would entertain the chair would entertain a motion to lay it on the table. Motion is laid on the table, subject to call. All in favor, say aye. All opposed? Motion carries. Okay, Senate Bill, I'm going to call up Senate Bill 2202. This is, we passed this last year, the Senate. This is Senator Parker's bill, continuing child support past the age of majority. Any words on that, Senator Parker?
I guess for 7 years in a row, I will say ditto. I think everyone in here, has expressed any concerns they have. And again, the task force that Senator Wiggins put together did an excellent job of trying to create some language that addressed what has been done in 40 plus other states. And this is certainly well vetted by people who are much more intelligent than myself. The stumbling block last year is that we have a House member who has concerns of an adult child. I have had detailed discussions with Medicaid, and Medicaid is trying to find some language that would make the House member with concerns more accepting of the legislation. My opinion going into the session was, without that exception, on the other side, I wasn't going to bring it forward, but I do feel there's been some good progress in trying to get that remedied. I cannot guarantee that, but I appreciate the chairman's hard work on this with me to move it forward last year. And I would just appreciate us continuing to move it forward. And if we can't reach an agreement on the other side, then I will say, I'll see you next year.
Any questions?
Possibly.
Any questions? Do I have a motion? Motion is title sufficient, do pass. All in favor, say aye. All opposed? Motion carries. Senate Bill 2379, code books, Senator Boyd, that's came out of your committee.
Thank you, Mr. Chairman. Senator Sparks's bill. This was something that was requested by the group that works on the codification and looks at the cost of the code books. And so right now, like in the Senate, we have an opt-in procedure where we have to say that we would like a set of the books and the information with that. This would change this to anybody that's kind of set to receive the code here, that they would also have an opt-in option where you need to let them know that if you would like to receive that. Just trying to save the state a great deal of money if people are not using this. So that's kind of the essence of the bill. Any questions?
Any questions? I have a motion.
Title sufficient, do pass.
Motion is title sufficient, do pass. All in favor, say aye. All opposed? Motion carries. Senate Bill 2636, I received questions from the Secretary of State. There's some issues with it, so the chair would entertain a motion to lay it on the table, subject to call. Motion is laid on the table. All in favor, say aye. All opposed? That'll be laid on the table, subject to call. All right. Senate Bill 2382, call that up. This may be fun for all of us. I think it's, I think as we all know, the reputation of the lawyer profession is always being challenged. And one of the things that I always hear is about these commercials. And so this is a simple bill. What it's saying is that if you're a lawyer and you are not admitted in the state of Mississippi, and you're running ads on TV and or billboards, that you have to put a disclosure that says not licensed to practice in Mississippi. And if Mr. Morgan and Morgan wants to come talk to me about it, he talk to us about it, he can do that. But what I hear is that people think when they see those that the attorneys are in Mississippi. And I think a lot of us know that that's not always the case. So that's a simple bill and that's what it does. Do I have any questions? Do I have a motion? Motion, title sufficient, do pass. All in favor, say aye. All opposed, that carries. Senate Bill 2640, there is in AET today, they will be taking up the bill to establish CPS. This language is similar, so wanted to see what would happen with that. So would entertain a motion to lay it on the table subject to call. Motion is laid on the table subject to call. All in favor, say aye. All opposed? Thank you. That one's done. 2716. For those that practice domestic law, you may be familiar with this. There is, and I would say it's judge-made or case law, where in custody matters and divorce matters, continuing jurisdiction. Well, what seems to be happening more and more is that the parties no longer live in the county where the case got started. That leads to a whole host of issues, including travel costs, because if, for example, if one person, and I've seen it, lives in Harrison County and another person, and it started out in Hattiesburg and both parties live down in Harrison County, they both have to go up to Hattiesburg to address any modification or anything like that, which it seems honestly a little bit silly, where they could just file in Harrison County because they both live there. So that's what this bill is doing, is allowing on any new continuing jurisdiction that you have to file, that it can be filed in one of the places where the parties reside. And that's what the bill does. Do I have any questions? Yes, Senator Turner Ford.
Thank you, Mr. Chairman. So what occurs, or what about a situation where, let's say the divorce was granted in one county and one of the parties has moved, but the one party still lives in the county where the action was originally filed? If the party that has moved wants to initiate some sort of court proceeding, they would be allowed to require that individual to come to where they live to respond, or?
If you look at line 16 and 17, so that's the optimum. If one of the parties to the original decree no longer resides in the county where it was enacted, venue for any subsequent matter shall be proper in the county of the original filing or in the county where one of the parties resides.
So both of them would have had to have moved?
No,
the
it
original?
can be there, and it can be up to the judge. It would be a venue question. And I've heard, talking to different judges, the reality is, in the situations I've described, they're actually granting venue changes when probably they shouldn't, to be honest with you, just because their dockets are. So what this language allows is, it wouldn't, if the party still resides in that, it would still be good to file it in the county where it was originally decreed.
So it could be, but
This just
nothing
gives them
prohibits
another
it
option.
from nothing prohibits let me cite an example, I guess. Let's just say a married couple lives in Hines County and they divorce, father moves to Harrison County. And the Harrison County spouse can require the person who never left the original jurisdiction to come to Harrison County to litigate a case.
Well, the venue would be proper, but it's up to the judge to make that decision. Yes.
Thank you.
Under the bill as it's drafted, yes. Have any questions? Senator Barrett?
Yes, sir. Thank you, Mr. Chairman. Isn't this an option as it stands now? I mean, it's a simple motion to,
No, it's, from my understanding of the law and the research, it's not. That the continuing has to be filed to Senator Turner Ford's example. If you're the party in Harrison County, you would have to still go file it up there. And also, if got divorced in Hines County, both parties actually moved, let's say one to Harrison County and one to DeSoto County, you would end up having to go back and file it in Hines County.
sure, you'd file your modification pleading, but your
Correct.
subsequent pleading would be a motion to transfer, right?
Yes, but you
could.
can't do that now. Correct.
I transfer venue frequently.
Well, there are places, okay, and that's good, but there are places in this state that don't allow that to
Oh,
happen.
okay. And this just clarifies that.
Yeah, council just told me there's case law that says it shouldn't happen. So to your point, I think it may be allowed, but it's not being consistent. And the case law says it shouldn't be allowed.
Thank you.
Senator McCon.
Chairman, I guess my question will be, are we opening the door for venue shopping now? Because we do have judges in some areas that would not rule the way than others. I mean, any given judge in any county could change the way they're going to do it. So we open that door for some venue shopping to occur when we don't at least set that the original jurisdiction should have it first and then at the option. Because I think we've just opened the door for way more than maybe we probably should.
I think your question is valid. I think that I don't think we are opening it for venue shopping because it's limited to where the parties reside. Okay, and and we all know you have to reside 6 months in a place. Okay. Also, there are places that are not, are unfair, I guess you'd say. And parties move around. And I think that there is, if there is venue shopping, it's the only two places where they reside, where the two parties reside. So honestly, I think you only have two options. And the question is which option is better? Well, that would just have to be decided by the judges.
Well, but so you're not throwing a little bit more of a requirement on judges? I know that you said that there were some that said that their dockets were pretty substantial. We're trying to send them somewhere else, or somebody else has to deal with them. But are we not?
I'm sorry, Senator Barrett just said that he was getting it done, and council says, case law says they shouldn't do it or can't do it.
The clarification there, I believe, is that once both of them have left the current jurisdiction, then they could file the motion and have it transferred to where one of the two of them are, is the way it actually, that I've seen it work in Chancery. I've not ever seen this happen with a single person moving away and then an actual judge giving up jurisdiction or venue for that would not be proper there. But I have grave concerns about this because I think we've created something that's very, very clear in the statute, and we've made it a little more convoluted in here, saying that, well, they could run up here and file, but we're originally here. And then you are putting a little bit more of a burden on someone who is living where they were when they were married for 20 years and got a divorce, living in the same spot, and then someone moves off establish a residency there, and now you do have to go. Even, and another question there would be, what happens when you have conflicting? The two judges then are gonna have to get together and rule, or one's gonna rule that I'm better than you and I'm gonna take it. So I really have grave concerns about this, but, and I understand some of yours, and maybe the redistricting will assist in some of those caseloads that we're talking about here. So, thank you, Chairman.
I think you're well noted. As counsel reminded me, this is not a statute. This law is case law. So there is no statute that governs this. This was created by the courts a long time ago, which has now led to some other issues we're trying to address.
I will go check, but I think
There's a venue transfer rule, but then it gets trumped, for lack of a better term, by this continuing jurisdiction case law.
And what is that case, I guess? I mean, we keep talking about, I guess my question is excuse me, Senator McCon was saying, in cases where both parties leave, I've certainly had no problems in getting a change of venue to the proper forum. So I guess, and I know there's rules on civil procedure, and we all know these rules and rules of federal procedure that mimic these. I just think that it may be creating a situation where, we may want to discuss this more.
Personally, I certainly would entertain an amendment to that where both of them, and I see what you're saying, to where both of them no longer reside in the
Right.
county. I think that certainly is a bright line. And so if you want to do an amendment, I certainly think that's a good amendment. Doesn't sound like you want to.
Well, I don't know if it's ripe, I guess, since we're talking this sort of thing, but I'll just see what happens.
Okay. Senator McCon?
So let me get this cleared up, because if we have some conflicting case law rules, I would absolutely want us to get that fixed. And if my understanding is that the chair is not at odds with an amendment that would clear this up and set there, where if both parties moved, then venue would be proper in the county of the original action or in the county where one of them. But now the only thing there is we may have to clear that up further and say, once it's established there, it's set. So we don't have residing, cases one's in one county, one's in the other county, original action. So I think I think there's potential for language to be put in there, Chairman. I would have to have a little more time than right now to formulate that language. If you would allow me that.
Yes.
So I would move that we table this subject to the call of the chair would be my motion, Chairman.
Okay. That's the motion. All in favor, say aye.
Aye.
All opposed? Tabled subject to call of the chair. And if you can work on that, then we could bring that back up. And I do think that that's obviously a fair request to do that
Yes,
in
thank you.
addressing these issues. Okay. And then I think the last one we have is Senate Bill 2652, Mississippi Vulnerable Person Abuse Registry, Senator England. I'm sorry, did I?
Thank you, Mr. Chairman. I believe this is Senator Boyd's bill. I would like to ask that she be recognized
Sure.
maybe to discuss, or, I'm happy to, Senator Boyd. I just didn't want to jump ahead of you on
Go ahead.
your bill. So this is a bill that was requested by the Attorney General's office. They've had difficulty in the past with, and I'm sorry if I can flip to the correct page here. We've had difficulty with elder abuse and with different types of abuse, like like that. This is just going to create a registry at their request that they will set up when anyone's convicted or anyone's been reported to them to have committed elder abuse or any type of abuse to anyone that's disabled like that. And I know that we have even colleagues in our own chamber that have dealt with hiring individuals to come into their home to help a loved one. And this would be a publicly available list for them to go to and see if somebody is on that registry before they hire that person. And that's essentially what the bill does, just creates this registry for us. Again, it comes from our friends at the Attorney General's office, and they've requested this specifically.
Oh, thank you. Council reminded me there is a reverse repealer in this, and
That is correct, Mr. Chairman. I apologize for not mentioning that. We did have some discussions in the subcommittee that I thought were very good discussions with regard to whether you have to be convicted to be put on the registry. We agreed to put the reverse repealer in the bill to give us some time to look at that, to allow us to discuss this with Senator Boyd and any others, and with the Attorney General's office, to make sure that we're passing a law that works for the purpose that it's stated to work for. And that's why the reverse repealer is in this bill.
any questions?
I'll just say,
Senator Boyd?
the Attorney General office approached me, but it was because of conversations that I'd had with them over a number of months ago. As you'll know, that I had to care for a father that was ailing for a number of years. And so hiring caretakers is something that you have to do, and you don't know that if somebody's coming, if they've had any type of abuse before, if they've been convicted of any crimes like that. And I have now met with a number of families, because we all start swapping people when we find out that people are good, but there's no like centralized registry. There is registries in other places that you can find out, particularly if you're dealing with an individual that's disabled, that they have to have somebody for the disabled children. Having those registries and seeing some of the abuse we all see in the news that has taken place with that population, having the centralized registry would be a great service to the public, but not just for the public, for careful as well. As I've gotten to know people that are in that industry, they are clamoring for this type of registry where that they can run people through and see if there's any type of, with that. So there's kind of a process where the Department of Public Safety already operates a registry. So this is something that is not a completely new process to them to be able to do. So they've been looking at taking this on. So that's just kind of a general explanation why there is a real need for this registry.
Senator England, you had a question?
Not a question. I just wanted to follow up with what Senator Boyd said on this bill, and I appreciate her speaking to give me some time to catch up with our agenda. I tried to step out for another committee meeting and didn't know if we had taken this up already. But this also is, I just wanted to point out, this is modeled after other states that have done the same thing. I think Senator Boyd hinted at that or mentioned it, but there's states around us that have done this and it's working. And so this isn't just out of the blue. This is something the Attorney General really liked, that once she looked at it and how it was working in other states, and it is working in other states. I just want to point that out to the committee members before we vote. And I do have a motion at the appropriate time.
Now's the time.
Okay, well, thank you, Chairman. The motion is title sufficient, due pass committee sub.
Motion's title sufficient, due pass committee sub. All in favor, say aye.
Aye.
All opposed? Motion carries. Looks to be, do I have a motion to rise and report? Rise and report. All in favor? Motion carries. Thank you all very much. Appreciate it.
Yeah, that's a good idea. And like, I didn't know all that.
We're actually not taking up 2606. Yeah, it's supposed to be on the list. Yeah. Oh, the other one is not on here. We do have. Yeah. Yeah. I understand. Are we having a meeting? We have the environment? Okay. Hey, I appreciate you being here. Who's handling that? Yes. It doesn't matter. We don't have to. The committee one. Yeah, I do want to have that conversation quickly with, because Senator Barr is going to stay here for that one. It doesn't matter. I can start. Call this other one to order. Daniel Brandy, Senator Black.
Yeah, if you're on it.
Actually, we don't even have to have that number. Okay, sure. And I'm gonna let you know that the information's over here. The packets are over here. Please pick one up if you're interested in one. Pat had to go to another meeting, so we're gonna let her go on that one. We are gonna call up a few of these. One or two of these may end up just being for discussion. That Senator Barr is still here, so we'll get him in here in just a moment. We're gonna call up, the very first one to call up is gonna be 2073. 2073 is brought to us from Senator Hill. There's a separate proposed one in there. And the bankers have been interested in this, among others, in the building. Senator Hill's goal is to reduce the age of majority for the purpose of real property and mortgages from 21 to 18 to allow an individual who is, who's now 18 years old, that has moved out and is working to be able to secure adequate housing. So do we have any questions on those? Yes, ma'am.
Changes that the bankers proposed. I have seen the bill prior to those changes. I just want to be sure I'm picking up on those.
So Ethan can go through those for us of the additional changes.
Lines 5 through 8, just added to the long title repeal of that section 9331, which was removing disability only in a limited spot of home contracts. It wouldn't be needed anymore, that section. And then if you look in section 3, section 2, on lines 42, it says, except as otherwise provided by law. And then also on lines 44, there was just a slight change from mortgage to a contract, enter into a contract affecting personal property or real property. That was just a reference to contract, but you need the full, it's just to mirror section 1, the language of section 1.
Thank you.
Senator McDaniel, you have any questions on that one? Title sufficient do pass is the, on the committee sub. All in favor, say aye. Aye. Any opposed? All right, so we'll report that one to the full committee for next week. I have Senator Johnson here now, and he's got a bill he wants to bring up. 2077, you're recognized, Senator Johnson.
Thank you, Mr. Chairman. So this bill just raises the audit threshold or requirement for charitable organizations from $500,000 to $750,000. This came from CPA, actually in the Laurel area, where I guess as a result of inflation and people making donations, charitable organizations are hitting new thresholds on how much money they're bringing in. And most of those in that range don't have a lot of cash left over for an audit. And most of them, she said that she sees are just barely hitting the threshold of 500,000. And she thinks that upping it would be a benefit to keep them from having to file an audit. And that's an explanation of the bill.
All right, any questions on that? All right. Title sufficient do pass the motion. All in favor, say aye. Aye. Any opposed? All right.
Thank you.
Senator Johnson, thank you for coming in on that one. 2606 is another of Senator Johnson's. We're going to pass that one this year. I believe he's going to do a little more work with the different bars to make sure that he gets that like he wants it. We have one on the table. We have one other bill out here, and Senator Barr, Mr. McDaniel, did he step out there? And this may end up just being a quick discussion over this as to, thank you. Oh, did you get that? Okay. All right. While he's doing that, we'll go ahead and call up the last one here, which is going to be 2197, which was it was tabled subject to call. So I would entertain a motion to bring it off the table there. All right, motion to bring it off the table. All in favor, say aye. Aye. All right. So this bill has been brought to us by Senator Seymour, Chair of our Military Affairs. There was some language that was rather general that Senator Branning brought to our attention. There's been some changes in this, and we're continuing to try to tighten it up. The current language says, of course, county Veterans Affairs officers be authorized and empowered to act for a veteran under a written power of attorney authorized by the veteran for the purpose of assisting with claims, benefits, and appeals in an administrative hearing before the United States Department of Veterans Affairs in any of its boards or departments, and shall be immune from legal action only for such actions in cases of exception for cases of fraud, abuse, and breach of fiduciary duty. Senator Branning, do you think we've tightened that up enough, or do you think we need more?
I think it's certainly better than it was. Do we have, Colonel McDaniel has blessed it?
So I believe he is actually here on another bill. We do
Okay.
have veterans here, though, on this side. So you want to be recognized to speak on this? Come up to the mic if you don't mind, because it is still streaming. And you may have to push the button to move it to green. And you're Ms. Caldwell? That's what I thought. Tell us about that language and let me know if it's.
I'm Kathy Caldwell, General Counsel for Mississippi Veteran Affairs. Basically, I know what was confusing is that you thought it was a court of law that we were giving them permission. This is just a power of attorney so they can handle their benefits and their claims and their appeals in the VA, federal VA administrative process. So we got a little bit more specific so you could understand it in that.
Thank you. So you don't have concerns with this language as far as any veterans being subject to abuse otherwise saying, I guess my main concern in the beginning with the initial language that you saw was that if we had a veteran that had given a general power of attorney to a rogue VSO, and you can see where financial abuse and fraud could take place, but you feel confident with this language that that would not be as
Yes.
prevalent.
Yes, the power of
Okay.
attorney just is for being able to see, of course, they'll get to see some of their medical claims in this, but it's for that specific purpose only.
Okay, and this seems to coincide maybe with some federal language that you deal with, I think, in your
Yes,
office.
yes.
I understand from council.
Yes.
Okay, thank you for your assistance on this. We appreciate it.
And just to clear that up one more, for, I believe the other question was, this did not extend to allowing the person to be over a veteran's finances. Is that right?
That's correct. It will not.
Okay,
My concerns are addressed. I appreciate, and I have a motion at the appropriate time.
all right.
Title sufficient to pass, committee sub.
Motion is title sufficient to pass committee sub. All in favor, say aye. Aye. Any opposed? All right, so we'll report that to the main committee. The last thing here, we do not have Senator Barr here. Mr. McDaniel, you are in here because there's some questions and some concerns about age of majority, and you have some other bills you're working on that. The thought might have been that this bill could be the vehicle just to clear up all of those concerns. Is that right?
One of those has been taken up in military affairs. One of those was actually taken up here today in relationship to the property. As my understanding, we've had issues with this before. It's also my understanding that Mississippi is one of only 3 states. The only state that has 21 as age of majority. 2 others, I believe, Alabama and perhaps Kansas have 19. The remainder of those have the age of 18. This is becoming more of an issue on a more consistent basis with us in the military on other matters, especially in relationship to the insurance. And that was a request, since it had come up with other agencies that we're starting to get more specific bills where it's consistently lower. I do understand also this came out last year from the Senate, that it did pass out of the Senate, the same bill.
So this is essentially the same bill as last year. The concerns, of course, that I had last year were, what are we doing with regard to child support? Because the judges absolutely had some major concerns with that. And that's an area. Do you know if that was taken out of this bill?
I don't know the answer to that. I can find out.
Council says it should not be in there. I've not had an opportunity to go through all 1,500 and some odd lines in here. Specifically, I do hate, I do have this concern also that this will be our last meeting on this subcommittee for this side. Senator, would you entertain maybe either reverse repealer or something to keep it moving, or even moving it to the full committee for further discussion? Or do you have concerns about that?
No, I don't have concerns. I think that we move it to the full committee and continue the discussion. I think there are a lot of members there. They'll have things to add. I think that we can make it better, but I support the idea. I'd like to see us keep it moving. So my motion at the appropriate time is going to be title sufficient to pass.
We'll entertain it now. Title sufficient to pass is the motion. We're going to move it to the full committee. We'll let Senator Wiggins. So all in favor say aye.
Aye.
Any opposed? All right, that's going to be it for our subcommittee. Thank you all for working with us. Rise and report. Thank you, Senator, for sticking around.